Hi, guys. Merry Christmas. It's Kathy. I hope you're doing well. Whew. We made it to Christmas. Whether you're ready or not ready or whatever, we made it to Christmas and it'll be over soon. Yes, it will. Happy Hanukkah. Oh, there's one more, but I can't remember what it is. So if you celebrate something different, tell me what it is and Merry whatever that is. Whatever you're doing today. My son's very loud today, and there's nothing I can do about it. So, I got some good stuff today. Good stuff today. Festivus. Merry Festivus. Happy the merriest Festivus to all of you. Of course, I'm on today. I'm on every day. Happy holidays. Kwanzaa. Thank you, Donald came in for the win. Happy Kwanzaa. Merry Kwanzaa. Festivus Kwanzaa. Snoopy, I didn't see what you said. Oh, there. Bill's going to interview you. That's wonderful. I want to see that. I'm going to see that. Don't don't ask him to grab your butt. Don't don't do that. Do something else. Okay. Let's just watch some court videos and get ready for today because, family and stress and fighting and let's just watch some court videos. All right, I don't know if you remember. A lot of you will have no idea what I'm talking about. Almost all of you, I suspect, will have no idea what I'm talking about. When I first started streaming, I had what I called my crystal ball. So these are things that I suspect we were going to see in a courtroom soon. So these are things that happened that are not court yet that I suspect was going to be in a courtroom coming to you, coming to a town near you soon. I have two crystal balls today. Two. But first, let's go to Jersey. Let's start Christmas in New Jersey. I just I'm just gonna turn it down a little bit because I have a feeling it's a little bit loud. Because it's Jersey.
Understand?
There we go.
Yes. You can leave the booth now, please.
You can leave the booth.
Your name?
Hi, alternate. Welcome. Gunther, welcome.
Can you tell me your name and speak louder?
Bogart. NASIMBGR. I'm sorry, my voice is a little.
Your what?
Said my voice a little raspy.
Number
that's
6,
fine.
Your Honor.
That's fine. Thank you, Ms. Sorrell. This is number 6. Sir, is your name Nassim Bogar?
Yes.
Is there a decision on this
Booger?
case, Madam Prosecutor?
Yes, there is, Your Honor.
Mr.
I'd be in jail if my name was Booger, too.
Prosecutor, what's the decision, please?
Judge, I'm hoping that you see in that it has filed for DV detention.
Prosecutor.
I rewound it so you guys can see Sorrel. Ann, watch Ann. Ready?
What's the decision, please?
Judge, I'm hoping that you see in that it has filed for DV detention.
Yay.
All right, sir. So the docket number on this case is W2024-001-391-0709. You will be detained, sir. The state has filed a motion for your detention, but you must appear for a detention hearing on December 19th, 2024. That's on Thursday, before Judge Leet. Judge Leet will decide whether you will be released or not. After that day, your case will go before Judge Fuentes on January 27th, 2025 at 9 a.m. public defender or Hearn has been assigned to represent you, and they will speak with you before your court date. Do you understand?
No, I'm not understanding the charges because I didn't take anything.
You're not understanding the charges?
No. What am I being detained
Okay.
for?
No, those are two different questions. You want the charges? I'll tell you the charges. If you want to know why you are being detained, I don't know. And nobody here knows except the prosecutor. So when you appear for your detention hearing, that's why there is a detention hearing. Then they will tell you that. All right. You can leave the booth now, please.
Thank you, Snoopy. But Donald is not a boogermeister. No, he's not. Essex County, Fazzy. Essex. Okay. This is not a crystal ball, but it is a crystal ball. Like, I suspect that some of these people that committed this act, this was like 11 years ago or more. It was at least 11 years ago, though it could have been more. I suspect some of these people that have committed this act have been in jail once or twice in the last 11 years. This is not court, but it sort of is. It's like college court. Sort of. I think it's Florida. Anthony, thank you. Thank you so much.
Through and talking about the Chapter 9 material today, talking about mergers and acquisitions, alliances, and those kinds of things. That's been preempted. And unfortunately, I think some of you know, I've been here for 11 years. I spent 10 years before I came here at the Rochester Institute of Technology. So I've been doing this for the last 21 plus years. Probably delivered course content to tens of thousands of students over those 21 years. And there was always one lecture that I hoped I never would have to give. And unfortunately, that hope ran out. Because I'm going to give a lecture today that basically is the toughest one I've ever had to give. And for some of you, it's the toughest one you've ever had to hear. When the midterm exam ended on Friday, a week ago, I looked at this data from the midterm exam, and at first I was just looking at the running statistics for the exam, and the exam was running about a grade and a half higher than it ever had run before. I thought that was rather interesting. It kind of set up a little bit of a red flag, because with 600 some odd students, and basically a course has been taught fundamentally the same way for the last...
Michael, you heard this lecture, didn't you? You were in this class. It's your fault that he made this lecture. Michael. Snoopy. I'm glad you studied. Thank you.
4 or 5 years, you don't see that kind of a grade improvement by chance. Once the exam ended, I ran more complete statistics on the exam, and what I came up with, or what came out of that, was something that looks like this. All right, and I'm comparing the summer 2010 capstone course, which I taught, to the fall 2010 capstone course. In summer 2010, this is the grade distribution. It's virtually a standard normal distribution around the mean. You'll notice that there's a single peak in the distribution and that the tails of the distribution are relatively equal, with the exception of the one student down at the bottom who basically scored a 60 out of 200. It's a relatively normal distribution. That's what it ought to look like. There are about 400 students in the course in the summer. This is the grade distribution from this semester, and I think you can immediately notice the difference. This is what's called a bimodal distribution. Bimodal distributions exist when an external force has been applied to a data set that creates a systematic bias to the data set.
I all of a sudden miss Bill so much. He would love this.
Now, on Sunday when I ran this, I didn't know what the systematic bias was, but I knew that it was there. On Monday, I found out what it was, because a student, either through a guilty conscience or as a heads up, anonymously dropped this in the bin on my office door. This is, as some of you out there know, because some of you out there are also in possession of this, is the complete test bank for the midterm exam. During the course of Monday, the lab instructors basically took a look at the data, started receiving emails from students who were concerned and upset that classmates had been bragging to them that they had advanced copies of the exam and that they aced the exam because they had all the answers ahead of time. Guess what? The midterm exam grades are being tossed. Whatever you scored on the midterm exam no longer exists. Everybody in the capstone course is going to be required to retake a new midterm exam. And before I get into the specifics of that, I want to thank all of the lab instructors and all of the team for working virtually nonstop over the course of the last 96 hours to write a completely new exam with about 200 questions to choose from, none of which, and I repeat, none of which come from a test bank. So whoever has the test bank for the midterm, it's worthless. And I'm presuming you also have a test bank for the final exam, it's also worthless. Because as soon as this exam is completed, the entire team is going to write a completely new final exam with 0 questions coming from any test bank. Over the course of the past 4 or 5 days, your lab instructors, academic services, and the Office of the Dean have begun and are continuing a forensic analysis of not only all of the data, but all of the available traffic over all of the available environments that possibly could provide us with better information about where this started and how widespread it is. Let me tell you where we are right now. Right now, we've narrowed the pool of participants to about a third of the class. So when you get into your labs this week, just to give you some idea of the perspective of that, when you get into your labs this week, look at the person on your left side, look at the person on your right side. Statistically, one of them cheated on the exam. Now, we had 2 options. One was to basically just simply scrub all of the other activities through the rest of the semester, cancel the capstone competition. But that would have been unfair to the 2/3 of the class that was honest and ethical and tried and did it right. But I want to send a clear message to the ones who started this and the ones who propagated it and the ones who encouraged it over the course of the weeks leading up to the midterm exam. As I said to the Associate Dean for Undergraduate Studies when I met with him late last week, I could give him a list today, and I could guarantee him with about a 95% certainty that everybody who cheated on the exam was on the list. What I couldn't do was give him a list and guarantee that everybody whose name was on the list cheated on the exam. That was going to require some further forensic analysis of the data. We expect to have that forensic analysis of the data completed by the end of this week. At the end of this week, we will turn our findings over to Academic Affairs, And at that point in time, the options and the results and the conclusions are out of our hands. They will do what they need to do to protect the integrity of the university and to protect the integrity of the college. I don't want to be the one to have to explain to your parents why you aren't going to graduate. So I went back to the dean and I negotiated a deal with the dean. Unfortunately, the deal has a time limit, and the time limit runs out at 7 a.m. on Monday morning. Because that's when we're going to turn the data over to academic affairs, and at that point in time, they're going to take over and do their own investigation, and they're not happy. So here's the deal. If you participated in this, you have a choice. You can sit back in silence and hope your name doesn't get caught in the net, which is very quickly closing around the participants, or you can individually, quietly, one by one, anonymously if you wish, to the rest of your classmates, identify yourself to your lab instructor. If you do that, get to complete the rest of the course. The grade you get in the course is the grade you earn in the course.
Or y'all can just shut the hell up because they can't prove nothing. Just shut up. If y'all just shut up, they can't prove nothing.
And providing you complete a 4-hour ethics course being offered by the folks over in academic affairs, any permanent record of this will be wiped from your transcripts. There'll be no further action taken. So the choice is yours. If you want to take a high-risk gamble, take it. I challenge you to take it. Because we know who you are. We know where you are.
Liar, 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 liar.
And when academic affairs is done, you'll know the outcome. And oh, by the way, for those of you who think that this is something that we caught by accident, college has informed every faculty member in the College of Business and every faculty member at the University of Central Florida that if they're using a publisher's test bank, that the test banks have been compromised. So if you've got a test bank from somebody else's textbook you think you're going to use, don't even dream of it. I've also been in contact.
Yep, what is our favorite defense in court? Wasn't me. It wasn't me. I'm going to hit this little boy. But it's not child abuse if I hit Anthony because he's an adult now.
Contact with every single one of the major publishers who publishes his textbooks that are used by the College of Business. They're not only aware of it, but 2 of those publishers have turned the matter over to their legal staffs to pursue whatever legal action comes out of the investigation. The information's also been shared with the Academy of Management and every organization that deals across college campuses, and I met in Atlanta, Georgia with faculty from 20 universities and shared it with them.
And I notified the President of the United States, and the military are forming right now.
The days of being able to find a new way to cheat the system are over.
Oh, that didn't age well.
They're over. Not just for this course, but for this university. This kind of behavior will not, cannot be tolerated.
$5. Send me $5 and I'll give you any exam from any college across the country. $5.
Know who you are. To say I'm disappointed is beyond comprehension. Physically ill, absolutely disgusted, completely disillusioned, trying to figure out what was the last 20 years for.
I think Florida.
For those of you out there who acted ethically and acted honorably and did it right, you have my undying gratitude and my utmost respect. For those of you who took the shortcut,
You know why he's talking so long? You know why this is such a long lecture? Because he doesn't have class ready for today. He's not prepared.
don't call me.
I do that too with my stream.
Don't ask me to do anything for you ever again. The midterm exam makeup
Nobody's in the room.
will open at 7 a.m. on Monday morning, November the 8th. It will close at midnight on November the 10th. It'll be open for 51 hours.
Do you guys know about OpenCourseWare from MIT? You can go on to MIT sites and they have like thousands of their lectures. Well, here, hold on. I'll show you. It's really, really, really cool. So, this is OpenCourseWare from MIT. And you can just, I mean, they have so many classes. They're real classes that they teach people in MIT. And you can go ahead and you can sign up for one of these classes and you can take one of these classes. No, you won't get a college degree off of this. It's just to learn something. Okay, so I'm just going to pick one. So, if you look at these videos, it's not going to let me. If you look at these videos, the teacher is often teaching to an empty room, and they tell you that. So you get to see these teachers just making a recording for themselves, teaching to an empty room. And some of them are quite old. Some of them are very new. But it is pretty cool that you can just go to MIT and watch any of their lectures. It's really, really, really cool. For free. Snoopy. I know we all know that, Snoopy. We all know. Thank you so much.
That's it. Those are the hours you get to take the makeup exam. I don't care what's on your schedule. I don't care what you have planned. If you have to give birth, you're going to give birth in the exam room. Because it's going to have to take a signed, hand-delivered note from God for you to get out of taking this midterm exam. So adjust your schedules, blow off whatever it is you have to blow off to be there. But this is a one shot, one time, 7 a.m. on Monday to midnight on Wednesday. If you miss it, too bad. It is mandatory for everybody.
Even those that did not participate.
Yep, and you can thank your teammates and your classmates and those that did participate for providing you with the opportunity to do this. I tell you how frustrating this has been. I didn't even have the wits about me in the last 9 days or 8 days to actually load the slides for the Chapter 9 presentations. So I literally have, unless I have it on my keychain, I literally don't have the material available to me to be able to present it.
Dr. Snoopy, thank you. Thank you, Dr. Snoopy. Okay. Exactly. No, 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 not right now. I freaking hate this mute button. I just really hate it. There's no sound in here. This is my other crystal ball. Okay? This lady or man who's ever driving looks like a lady to me. Um, she's definitely in jail. Definitely in jail for this. Definitely. But who knows? Maybe not. There's no sound because the police siren just woo 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 the entire video. It's shorter than the first video. But I muted it because it's just annoying. So we can just talk while it's playing. But this driver is excellent. This is an excellent, excellent driver. Here we go. Yes, there's no audio. Yes, there's no audio. Yeah, that's how long I could handle it. It was very annoying. So I got this on my phone while in between tables while I was at work. Oh, oh. Jesus. Yeah, I realized, Donald, there's nothing I can do about it. He's telling everybody they're beautiful and he loves them. Tase him. Oh man, this is why I can't have nice things in this house. If I had a taser, he'd be in big trouble. Oh, did you see that? Did you see that? Hold on, hold on, hold on. Look at this. Look how terrifying this is. That's a person. That's a person walking across the street. That is freaking terrifying. Fozzie, we got a picture of you driving to the beer store. No, he doesn't pay bills. He makes bills. He creates bills. Got him a new bed for Christmas, though. So maybe he'll go upstairs and get more sleep. It, they should do something. This guy's going to kill everybody. Maybe. Maybe. Oh, he lost one. It is so dangerous. You lost. You. All right. I don't want to mute it because everybody's gonna think their audio is off. But I don't want to unmute it because of that. Look at that. Look, look. Woo. If I turn off the Wi-Fi, I'm in trouble. Spawn camp. No. Watch, watch. Did you see that? No, I was gonna get around that bus and he just jumped over. Look at this guy driving. I don't know where this is. Like what country this is. They're driving on the right side of the road, but this is not. It's not the United States. Does anybody know where this is? I mean, not exactly where this is, like what country this might be that has roads like this. Oh my gosh. Props to the camera guy. He didn't lose him once. There's a lot of buses here. No, she would be on her bicycle. Oh, I know. It is so scary. I'm thinking too, but they're on the right side of the road. They're not on the left side of the road. Oh. Oh my gosh, did you see that? I can't use that. It's copyrighted. I would love to put Benny Hill music on often. Very often. Oh, Beck, it's just temporary. He physically can't stop. Stop. Djibouti. I don't feel as scared when he's on a highway like this, but then when he's in the town, but it's still terrifying. Terrifying. Doesn't I think it has to be 100 years before it's out of copyright. There's no way Benny Hill's 100 years. Maybe it is. I don't know. All right, Maria, help me out here. Is it Jakova? Shakova? Hey, no. Yay. Imagine if the driver did not spill his drink. Listen, Fozzie, nobody heard that but you, so shh. He ran into the store. He jumped out of the car and ran into the store. And I don't know what that store is. Maxi? Does that help us tell where this might be? Oh boy. Terrifying. That is terrifying. Yeah, My Hot Wheels is. If I just went a little too fast, it went off the track. How did he do that? Okay. Let's get to court, guys. We're here to watch court. I'm going to bring this judge up because he's just great. I just love this judge.
Do I need a form or anything to take over?
Just go there and let them know you pled and what
Okay.
courtroom you're in. They'll
Thank you,
pull up
Judge.
the minute order and you get rolling.
Judge, we can call Mr. Omar,
Okay,
but at number 14 on the docket, when the court is ready.
well, I'm ready. It's called 23 CR 1931 People versus Ilumo Omar. Recalling that case.
William Kellen on behalf of the people.
Thank you.
Equal Omar on behalf of myself.
All right, Mr. Omar, you had a chance.
I feel so bad for this guy. I just feel so bad for this guy being pro se in jail. And normally that's stupid. Normally, we think that they're stupid, but this guy I feel so bad for.
To talk to the people. What are we doing today?
Yeah, I will let the people go first if he wants to.
Judge, I've spoken with Mr. Omar. We have discussed the status of his investigation into this case in terms of the motion that advisory council had filed several months ago. It's what I've discussed with Mr. Omar is that if he intends to conduct any investigation, that now is the time, and that I've let him know that I'm going to ask the court to inquire as to whether he's ready to move past that phase or continue to investigate. At the same time, Mr. Omar and I have also been engaged in discussions on a potential resolution of the case. And with the court's permission and the deputy's permission, I'd like to give him my business card so that if he gets access to email, he can
Serbia.
write to me with that in mind. But Judge, those are the matters that I've discussed with him so far.
Well, I can tell you earlier, I saw a defense lawyer handing out his cards and they were taking them happily over there, which much to my dismay. So you can certainly hand him your card. I'll ask you, Mr. Omar, what do you want to do? You want to set this over?
Yeah, I respect the position that the prosecution office just explained to you. I would like to set it over, but in the meantime, well, first, one thing at a time, I would like to address something else.
All right, go ahead. Let me know what that is.
Well, I don't have access to like the motions that I submitted. I know that, the attorneys on cases usually have access via computer, like accessing to see if motions were granted or not. And recently, well, a couple months back, I submitted a motion regarding the bifurcations. I hope I'm saying that word correct.
Yeah, you said it properly.
Bifurcation of charges. I just want to see.
Well, I don't think I've ruled on any of those things yet because we haven't even entered a plea, have you?
No, I haven't.
Here's what I'm going to do. I'm going to set this matter over to January 13th at 8:30 here, and I'm ordering Miss Workman to be here on that day. And I want answers from Miss Workman because I issued an order to her to get back to me regarding the help that you were seeking for investigative purposes. I have not heard back, and I've talked to her about that twice. I'm ordering her to appear, and I will issue a written order to that effect as well. So we'll see you back here for continued arraignment on, what did I say, the 13th?
Yes, Your
January
Honor.
13th at 8:30. So please honor that writ. So we're going to move this case forward in some direction, okay? You can certainly interject.
There's a trial for me set in January
What
in
day?
Denver. I'm not sure exactly. Is there any way we can?
Trial is January 26th.
The 13th will work out just
Okay,
fine.
that'll work.
Will not interfere with your trial. All right. All right.
All right.
All right. So January 13th at 8:30.
And Judge-
To Denver.
Writ to Denver, thank you.
No, one more small request.
No such thing as a small request, but every request is valid. What is it?
I just need a printout of these motions or just so I can get a refreshing of what I submitted to the court. So I'm aware, that I submitted motions. I just want a copy of those.
Well, Mr. Kellen, you have those motions? They should be, they're filed, right?
Judge, I do have access to the court file. I don't know the volume or the number offhand of what we're talking about here.
Well, I'm gonna take a look here.
It looks like on September 11th, there were I see three filings by Mr. Omar on September 11th. I think there may have been an initial batch prior to that, though.
I have motions for extension of time. And motion for advisory council, which I granted.
Judge, in terms of the recent motions, it looks like September 11th, 2024 was when a motion for an investigator was filed. I believe the court's addressed that. And then the motion it appears to be a motion for severance of criminal charges. That's how it's titled in the court file. Perhaps that motion is
I've
one.
got them. I've got copies. Hand these to Mr. Omar. We haven't got to that stage yet, so they're all preserved.
Okay.
Okay? But we'll see you on the 13th at 8:30. And we will also see Ms. Workman, okay?
All right.
And Judge, just
To
for
get
the
some
purposes,
answers.
my apologies, for the purposes of the record, I've handed copies of the three motions from that date to Mr. Omar in open court.
That were printed by the court, yes. Thank you.
These are two motions, Your Honor. I would like to.
Well, the third one was, I think, your motion for investigative or for advisory council, which I granted,
Okay.
right?
Oh, yeah. Oh, I see. Okay. All right.
Okay.
Thank you.
All right.
All right now.
Okay, thank you. We'll see you on the 13th, Mr. Omar. All right. Yeah, who are they? Well, no, hold on, just hold on a sec. Who do you want to call?
Number
7.
27, Mr. Blanco Zolorano's case.
All right, let's call 24 CR 1995, People versus Solozano Blanco.
Michael Arndt for the people.
Megan Leahy on behalf of Mr. Blanco Zolorzano, who appears in person out of custody with the aid of a Spanish interpreter.
Good afternoon, Your Honor. For the record, interpreter Lee Ana Trujillo Lopez, certification CO 22-101.
All right, thank you, Madam Interpreter. Good afternoon, Mr. Blanco Solozano.
Good afternoon.
This is our third arraignment. I understand a plea offer was extended last setting. Is that right?
No,
Oh,
Your
you were
Honor.
waiting on one.
That's right.
Was that ever extended?
No, I've spoken with Mr. Arndt today, Your Honor. Sort of firm offer has not been extended. The idea of an offer has been extended. It's my understanding that Mr. Arndt still has a victim he needs to reach out to speak.
So not a plan, a concept of a plan.
That's right.
I've heard that elsewhere. Okay. Well, we're on our third arraignment. When do you expect to actually extend an offer if you intend to do so, Mr. Arndt?
Two things. We do intend on doing so in a conversation I had with Ms. Leahy about this particular case. As soon as I can get the VRA done, my goal is to have that offer firmed up and extended by the end of this week.
All right, January 13th at 10 a.m. That'll be for fourth and final arraignment. If we don't have a disposition, we will enter not guilty plea and set the matter for trial.
Thank you, Your Honor.
All right, you're welcome. And we still have some folks in the back. Who can we call?
I believe this is Mr. Chihuahua. This is number 31.
Hold on.
Sorry, I have
Okay.
a Spanish
We have a special
interpreter. I'm sorry,
interpreter.
Mr. Arndt.
Call that.
Judge, could I please call number, I believe it's 47, Yolanda Miranda?
Yes, let's call 24 CR 2358 People versus Yolanda Miranda.
Hell no.
William Kellen for the people.
Thank you.
Yeah, it's not covered. And Noah Sweet on behalf of Miss Miranda, who appears today in person with the assistance of a Spanish interpreter.
Good afternoon, Your Honor. For the record, interpreter Lee Ana Trujillo Lopez, certification CO 22-101.
Thank you. Good afternoon, Miss Miranda.
Good afternoon, sir.
Okay, it's appearance of counsel. Is Miss Miranda qualified?
She has, Judge,
All
yes.
right, good news there. What would you like to do,
No.
Mr. Sweet?
Judge, just a continuance. We have a meeting set on January 3rd, so if we could go to January 16th, I'd appreciate that.
The 16th?
Yes, Judge.
No, we're not going to do that because that's a Thursday.
I thought that
I'll
was
give you the
Monday.
13th.
Sorry. It is
How's that?
indeed Thursday. 13th is
All
fine.
right, January 13th at 10 a.m. We'll see you then.
Thank you, Judge.
All right, who else do we have in the back? Anyone else need Spanish interpreter?
Gracias. Thank you.
Thank you, Madam Interpreter.
You're welcome, Your Honor.
Okay, let's call the rest of our cases from the back. And I know we have Mr. Marquez sitting on WebEx. All yours. How about Eric Mejia Ortiz? 22 CR 2105.
Michael Arndt for the people.
Noah Sweet on behalf of Mr. Mejia Ortiz.
What do you know? He refused transportation last setting. Not here today. What's going on? Do you know?
Judge, unfortunately, this case was assigned to me on Friday afternoon.
Yeah, you're probably heading off to happy hour Friday afternoon. Makes perfect sense. Where is Mr. Mejia Ortiz in our jail or where is he?
Yes, he's ours. He stated he didn't want to go.
Well, here's what we need to do. You need to you're a very convincing guy, Mr. Sweet, because you convince me on a daily basis to do something. So please have a conversation with Mr. Mejia Ortiz. This is a probation revocation that if he doesn't come next time, I'm going to issue a reasonable use of force, and I don't want to do that, but he's got to roger up. I can't imagine anyone who wants to spend any more time in the county jail and enjoy the food and not get these cases resolved. So please have that conversation with him. Yeah, but you keep working on your salute. It'll get better. All right. So we'll set this matter over to January 13th at 8:30. And please have that conversation.
I will.
Thank you. All right. I'm sorry. Thank you for your patience, Sheriff. I appreciate it. Is there anyone else?
Number 23, Judge. Same issue.
Oh, Mr. Zuhoff, let's call, yes, two cases. Let's call 22 CR 1302 and 23 CR 083, People versus Hunter Zuloff.
Like Clarence, the people.
And no suite on behalf of Mr. Zuloff.
He's in Denver, right?
Yeah, that's correct.
Is that correct?
Downtown.
Is this a writ failure? Because this is a ComCore rejection. It's a resenting. Who's representing you are, Mr. Sweet?
I am, Judge.
Have you had any conversations with him?
I have.
Well, without telling me the nature of those conversations, what are the prospects of him showing up in court without a reasonable use of force order?
Hey, Judge, we did try the WebEx last time and unfortunately he didn't show up. I do sympathize in some sense with Mr. Zuloff, Judge. He has somewhere in the ballpark of 10 to 15 new cases across all of the counties and all of them with serious charges. So my concern is that if we resolve these community corrections, which one of them is, then he'll be sent to DOC and it will make it extraordinarily difficult for him to resolve all of those cases while he's in DOC.
Not necessarily, because when someone is in DOC, we usually get at least in this courtroom, we readily get them up on WebEx at 9:30 and those cases move forward.
And my only response to that, Judge, is in order for me to visit somebody at DOC is just extraordinarily, it's a hardship. It typically takes up half or more of the day. So, that's really where he's standing with this. I told him about the use of force issue, but.
All right. Well, if what I hear you saying, my interpretation is I don't want to go to court because I don't want to get sent to DOC when he was a ComCore rejection. That's almost like an ultimatum on the court. Mr. Zuloff in both cases is
Thank you, little man. Thank you.
failure to appear will issue, bench warrant will issue in both cases. And I will issue a reasonable use of force order in Denver.
And we already have active warrants in both of it.
Is it, well,
Canceling those an issue.
no, he says I have to issue a failure to appear before I can issue the reasonable use of force order. So I'm doing that now. And I'm going through the mental checklist that I must do to make the sheriffs happy. I've gone through that checklist. Reasonable use of force order is hereby ordered. Let's set it over to January 27th at 8:30.
And Denver has them 27,
Denver has them for what?
for an arraignment.
All right, January 13th.
He's also set in Broomfield on the 8th. I'm not sure if that.
Like I said,
Well, I gotta get him here. I'm not gonna, yeah.
All right, Fozzie, that was long enough. You had enough time. Wash your hands.
It was surprising when I reviewed all the cases.
Well, let me ask you this. What date on a Monday does he not have court somewhere else? No, I don't want this to be like immigration court. We're setting something out to 2028.
He set all the way from December into January.
They laugh, but it's true. Immigration court takes forever. It's so sad.
Okay. What about February 3rd?
Get him in.
All right, February 3rd, please issue that writ to Denver.
Denver down to, I'll do both.
You do both. And that reasonable use of force order is hereby ordered. Both
Thank you,
cases.
Judge.
Thank you. Let's try to get him here and get it resolved.
I love that, Judge. I love it. Okay, we have one more. We're going to go to Jersey. This is two different judges in one. I know. Yes, it is. I gave you plenty of time. Let's go to Jersey. We're going to start with Jersey. We're going to end with Jersey.
Are you Derek Rodriguez?
Yes, Your Honor. Good morning.
Good morning. This is State of New Jersey versus Derek Y. Rodriguez. And it is under complaint warrant 2024-1585-0810. Counsel, your appearances, please.
Good morning, Your Honor. Assistant Prosecutor Kerner for the state.
And Ron Appleby for Derek Rodriguez, Office of the Public Defender.
Thank you, Mr. Appleby. So Mr. Rodriguez is here. This is following a 3-day postponement request that put the matter on to
I need this. I need this. I need this right here. I need a great big sign like this to tell me when I'm muted.
day, the 17th. So, is the state moving forward with this application?
Yes, Your Honor.
All right. Mr. Appleby, your position with regard to probable cause?
I'm not, well, I just wanted to make sure I don't have that many reports. I wanted to see what the state has. It looks like,
So, if you listen to them, this is Jersey, but there's like hardly any accent at all. So, would this be like West Jersey, or are the accents more north south? I'm thinking it's more West Jersey that is like this. Who's in Jersey? Who knows?
they have an affidavit, a CAD report, and photos.
That's correct, Mr. Appleby. Unfortunately, there was some delay with the incident report, but the CAD does include a narrative of the incident.
I do see that. Okay. I'm not challenging probable cause.
Right. So for the purposes of this
Thank you, alternate.
hearing,
Thank you.
probable
Merry
cause
Christmas.
is conceded by the defense. Ms. Kerner, what documents does the state rely upon for the issue of detention?
Your Honor, I would ask that the complaint warrant package be marked as S1 and that the PSA be marked as S2. I'm going to be proffering from the CAD.
Happy Christmas, Karen.
Mr. Appleby indicated he has a copy of. And I believe that's everything, Your Honor.
All right. Any objection to those documents, Mr. Appleby?
No, Your Honor.
All right. So they'll be in evidence only for the purposes of this hearing. I'll hear from you, Ms. Kerner, as to the issue of detention.
Thank you, Your Honor. So in this case, just by way of what the circumstances were here, there was an incident on December 8th where an individual with the initials JWC called 911 and indicated that her boyfriend, who she identified as this defendant, had struck her after she had been looking at her phone, and defendant demanded to see her phone and she refused. She then claimed that he had grabbed her by the neck and pushed her against the stove and then chased her out into the parking lot and punched her in the face. With regard to the weight of the evidence here, the officer on scene indicated that he was able to observe swelling and bruising to her face, specifically to her left cheek. Indicate the victim thereafter applied for a temporary restraining order that is not indicated in the PSA, but was noted in the CAD, and I did check earlier this morning, and I see that it is still active at this time. At the time of this incident, what's notable is this defendant's already on pretrial monitoring level 3. Specifically, I believe he's on level 3 for assaulting the same individual. Although it could be one, I would have to confirm that, but I know that the other. So I'm just going to go back for a moment. With regard to his current charges or the pending charges that he has against him, he's facing 11 pending charges in addition to this charge. There's an incident in Camden that's indicated from March 18, 2024, and he's charged in that incident with aggravated assault on a domestic violence victim. I did look that is for a different female, and that's for charges involving a kitchen knife. He was then charged on September 10, 2024 in Camden with aggravated assault on a domestic violence victim, specifically strangulation and theft by unlawful taking. And that's for the same individual, the same victim here. And that charge was for placing the victim in a headlock and taking her phone from her. And these are all from the complaints that are on eCourts. On October 2nd, this defendant was charged with assaulting a third female, and that's indicated in the Camden complaint. And
He's shaking his head like, no, no, it wasn't me.
he's charged with possession of a weapon for an unlawful purpose for that incident. For, I believe the weapon was a metal rod. And he's also charged with theft by unlawful taking and receiving stolen property. He has 3 restraining orders against him currently from the 3 individuals I indicated with pending charges against him. The active FROs are from the other 2. The TRO is from this individual. At the time of this incident, this defendant had a no contact order in place. There was no contact with the same individual, JWC. Initially, when this case was postponed, there was going to be additional charges added for contempt. There are still conversations regarding these additional charges, which I understand, Your Honor, is not to consider for purposes of today's hearing. While there were some delays with the report, that was part of the reason why these additional charges have not been added. But at this time, I will indicate that there is he was on level 3 for assaulting the same individual, and there was a no contact order in place, so there are no conditions of release that are appropriate here to show that this defendant will follow court orders and stay away from this individual, and that he will remain law abiding. Specifically, it's to be considered a threat to the community and to women in particular, as he appears to have in the past year a propensity for assaulting women. So based on this, as the state's position, the detention is appropriate here.
Mr. Appleby, I'll hear from you.
Thank you, Your Honor. I appreciate that police with evidence-based prosecution did photographs and then did a thorough inspection. And the officer says he did a thorough inspection of JWC's neck, upper chest, eyes, eyelids, had her pull her eyelids up and down for petechiae, didn't locate any abrasions, swelling, bruising, or petechiae on the neck, jawline, upper chest, or both eyes. Only visible injuries was a slight swelling there on the left cheek. Voice was not hoarse, not coughing, showing any injury distress to the throat, and also initially said that she didn't have any trouble breathing. And Your Honor, the risk scale for failure to appear is a 2, and for new criminal activity is a 4. I realize that there's the MVCA flag, current violent charge, but I would ask that Mr. Rodriguez be released on level 3, the same level that Camden has him under. I thank you, Your Honor.
Can I have
I just
both?
wanted to note something for
Both?
the record. I know what Mr. Appleby is referring to with regard to the officer making his own findings as in regards to the victim's injuries. I would note that the charge here is assault, that he saw injuries to the victim's face. With regard to strangulation, that's not charged at this time, and I would note though that the officer is not trained to analyze strangulation, and EMTs are not trained to analyze strangulation in the field. It can only be done in a medical setting. So I have nothing further, Your Honor.
Mr. Appleby, would you wish to respond to that?
Nothing further, Your Honor.
All right. So the court has had an opportunity to hear the proffer of both the prosecution and defense counsel to review the public safety assessment and criminal histories contained therein. In this case, Mr. Rodriguez stands before the court. He is charged with one. It's a disorderly persons offense, but it's a simple assault on a domestic violence victim. What is troubling in this particular case is, well, first of all, there was some slight swelling observed to the left cheek of the victim. Again, this is not a strangulation case at all, but although there was an observation by the officer of everything, but it was indicated she was struck twice in the face. That is the allegation.
Your Honor.
Sir, please don't say. All right? I'm giving my decision, so you need to listen rather than to speak.
So Linus comes in when the judge is saying, stop talking. You get to listen. He gets to speak. Merry Christmas, Auntie. Auntie.
This was a alleged to have occurred while there was a no contact order in place for JWC. It's also concerning to this court that the prior offenses which defendant's been charged here, I know that they are pending, was also involving the victim JWC. There's also 3 active restraining orders in effect, one for JWC, but also 2 other that are set forth in the and referenced to in the public safety assessment, which is concerning to this court. I'm sorry. There appear to be 2 restraining orders. There are charges by 3 separate women, but there are 2 restraining orders out of one, both out of Camden, FVCAM 115925 and FVCAM 2888-24. The one under FVCAM 894-25 indicates dismissed. But nonetheless, the court is troubled by that, in addition to the 11 pending charges against this defendant. And also, this is not a circumstance where there were, 1 criminal law event or perhaps 2 with 6 charges in one and 5 in another, or all of them under one criminal event. There are, again, of these 11 separate charges, they are on 4 separate dates of alleged activity. So all of that is concerning. The court's also concerned that this defendant is alleged to have committed this offense while he was already at the highest level of monitoring out of Camden County, sounding out of similar type charges to what we have here. The court is concerned about the safety generally because these are multiple women that are alleged to have been the victims of this activity. The court's concerned about specific victim here. The allegation is this is a victim where there was already a no contact order, already a restraining order, and yet again, this defendant is involved allegedly with her once again with violent assaultive actions. Specifically, the allegation is the defendant punched her in the face twice, along with other things. So all of that.
Your autocorrect is like my mute button.
This court finds that demonstrates that there are no conditions which could be placed upon this defendant that would assure his appearance in court to protect the overall safety of the community and ensure that this defendant would not obstruct justice. And the court's more relying upon the danger to the victim. There's a specific victim that's been victimized multiple times in violations of court orders, allegedly. The court's also concerned generally with the public because there are incidents involving 3 separate women, which were the subject of alleged acts of violence. Thirdly, the court is concerned this defendant would obstruct justice because he's demonstrated he's willing to engage in activity allegedly against court orders in place, that he's to have no contact, and there are restraining orders in place as well. Finally, the court is concerned about this defendant's appearance in court. I know that there are no failures to appear at all in this defendant's record, but the accumulation of these charges in fairly rapid succession over the course of, say, 4 months really gives this court, or I'm sorry, not 4 months, but over the course of this calendar year of 2024. There's sets of charges in March, in September, in October, and now in December. Very much give this court great concern about this defendant's adherence to any requirements placed upon him, which would include appearing in court for proceedings. So the court is concerned about that as well. The state's motion will be granted. The defendant will remain detained pending trial or other disposition of these charges. Sir, the state's motion has been granted. You do have a court appearance, and I'm just going to advise you when that is. For this case, there's inmate court, and it says it is today. I don't know if that's actually going to be engaged in today, but it could be. So they may have put it off till this afternoon, given the fact that you're in front of this court now. But there may be inmate court today. I'm unsure if that's going to be able to be heard today. The joint Mantua Township Municipal Court would be the court in which this case would proceed in. So, sir, you do have the right to appeal this court's decision. You have 7 days from today's date which to do so. If you cannot afford a private lawyer, you can employ the services of the public defender. You have to fill out an application, and if you qualify, a public lawyer could be assigned. Do you understand your appellate rights, sir?
Yes, Your Honor.
All right. That does conclude this hearing. Mr. Appleby, anything you'd like to say to your client?
Very briefly, Your Honor. It's just, I'm sorry you're detained, but there is one thing that could make this worse, and that would be contacting any one of these three women, either directly, indirectly, sending a message to them. You might feel you have a good reason to do so. You might call and reference one of them and to somebody else, and that could be interpreted the wrong way. Remember, everything's being recorded. Remember, things can be taken the wrong way. Just be very, very careful with that. That's all I have.
Your Honor.
Yes, sir.
I just want to say one thing. I do have on my phone evidence of Janani Ware Chavis, where that day she was acting very aggressive with me.
Yo,
You're talking
I
about the
don't
facts of the
care what you have on your phone. I don't care. I don't care what you have on your phone. Nope.
case.
Okay.
My decision. This is not going to be helpful to you. You can certainly address anything you want at the time that the merits of the case are going to be heard, and that would be at that municipal court proceeding. All right. So I'm just indicating to you, sir, you can present whatever evidence you want at that time, but I'm not changing my decision. I've made the decision. If you wish to appeal the decision, I've given you your appellate rights. And then otherwise, if it goes to the merits of the case, the specific facts, you can tell the municipal court judge if you wish to testify. I'm not suggesting you should. You may want to have a public defender for that proceeding, and you'd have to apply for someone if you wanted it, because Mr. Appleby can't represent you in that proceeding since he's only works in the Superior Court. So if you wanted a public defender, you'd have to advise the folks there in Mantua, and if you qualify, you'd have to wait to have a public defender assigned to you. But it's best that you not talk about the facts of the case, sir, since I'm not making a decision about guilt or innocence today. All right.
Okay. So when's my next court date, Your Honor?
Sir, you have a court date for today. Inmate court while you're in the jail. I don't know, because you were already here with me, whether they're going to conduct that hearing today. They may very well do that today still, even though you're here. Before me, they may you come out and they'll say, hey, you have inmate court, and they'll take you over to a different booth for that. That may still happen today, sir. I don't know. But you may want to, again, consult with an attorney. You'd have to indicate you want the services of a lawyer, and they could assign somebody to you. But that may cause you to have it heard in a different day than today. But you're going to have to discuss that with an inmate court when you have it, okay?
You can try.
All right, sir. You can step out of the booth. Right. I do believe that.
Before we go to our last clip from Jersey, I just wanted to give you guys an update on Clarice. Home now, recovering, out of the hospital. So, thank goodness, Clarice. I hope you're resting and taking care of yourself today. I hope you have a nice Christmas. I'm so happy that that you made it home. All right, Jersey. This guy was a huge letdown for me, but if I figured if he's going to let me down, he can let you guys down. When he walks in, I thought, oh, this is going to be great. And it's mid.
Good in here. Hello?
Yes, what's your name?
Christopher Soto.
Oh, you speak English?
Yeah, I speak English and Spanish.
Okay, I don't know why they put that you, okay. Mr. Clark, do you want to speak to your client in the breakout room?
No, I think we're okay.
You're okay to go before the judge?
Yes.
Okay.
It was not happening, Lord.
So we're gonna go in front of the judge. He's gonna make a ruling on what we discussed the other day, okay?
Oh, all right. Hopefully they let me go.
Actually, no, can I get a quick breakout room? If it's not a,
Okay.
thank you.
So, yeah, I know that a lot of people might be alone today. So, I have a couple trials, but I don't know if I have verdicts. And they're nice and long. I'm gonna as soon as this stream is over, I'm gonna go see what I have. I'm gonna go see what if I have a trial and a verdict ready, and if I do, then I'll be streaming a nice long stream today. So I'm not gonna do OJ today. Instead, I'm gonna go see if I have a nice trial that we can all. I mean, if you're alone, you can hop in and hang out with us for a while. We'll get through. We'll get through today. It's okay. They were just talking. I thought I cut this out.
Motion to reopen. This is Chris.
Yeah.
There.
Your Honor, we're ready to proceed with State of New Jersey versus Christopher Soto.
Good afternoon, everyone. Versus Christopher Soto, charged in complaint warrant 2024-817-2012. This is on for a motion to reopen detention. May I have the appearances of counsel, please?
Thank you, Your Honor. Good afternoon.
Good afternoon.
Prosecutor Myra Pius on behalf of the state.
Good afternoon, Ms. Pais. Mr. Clark.
Good afternoon, Your Honor. Malcolm Clark for Mr. Christopher Soto Tashaz, seated in the booth.
Very well. This is your motion, sir. I'll hear from you.
Thank you. I think we'll submit largely on the papers. We've obtained placement for Mr. Soto in a treatment program, the Cura program located in Newark. As the record reflects, Mr. Soto was alleged to have been using drugs at the time of his offense, and I believe that his drug use has played a role in his prior criminal history. He's also communicated to me that he's been on the MAT program, which is a drug treatment program, while he's been incarcerated. Also, after his arrest, he was taken to a hospital where he was prescribed Suboxone.
Almost. I mean, almost. Discord is different. It's more like this chat right here in an app. So just the people who are in it can see the chat. The chat keeps going, but we have different rooms. So like here we have one chat. We have a whole bunch of different rooms in Discord. We have a general chat, and then you can talk about your dog in the animal chat, or you can post memes, or we have a voice chat where you can actually talk to other people, or I mean, there's a lot of different things you can do in Discord. You can play games with each other, like poker. So, I mean, you could try it. The link to it is in my description. If you don't want to download the app, you can use it in a browser. And it's nice because we're all there all day long. It's 24/7, so make sure. Oh no, it's free. It's free. Just make sure you learn quick how to mute it, or your phone will be dinging over and over again, 24/7. It's great. It's really great because you can talk to any of us at any time.
Mr. Soto has a history of drug use. I believe that a proper inpatient long-term treatment program would help him address those drug use issues much better than the Essex County jail can, and that would ultimately be really useful and helpful in his rehabilitation and would enable him to become a productive member of society. With that, I submit.
So, yeah, thank you, Mr. Clark. You said it, and I just wanted to confirm that we're both on the same page. You said a long-term residential drug treatment program, correct?
That's correct.
Okay. Ms. Pais?
Thank you, Your Honor. The state submits
Merry Christmas, Ms. Glow. Merry Christmas.
all previous arguments made. In addition, we ask that Your Honor, that the defendant remain pending the disposition of these charges as they do relate to domestic violence, in particular a third-degree criminal restraint, a third-degree burglary, a third-degree possession of controlled dangerous substances, and a disorderly person's possession of controlled dangerous substances. The availability of the treatment program does not alleviate the state's concern that this defendant poses a danger to the community as well as the victim. If released on the treatment program, there are no assurances that the defendant won't just leave and disregard the court's order. The defendant is facing multiple domestic violence charges. The defendant was currently on release on a PML-2 only about 3 months prior to a second-degree robbery. Additionally, the defendant has shown by his own actions that he will disregard any pretrial services recommendations and or court orders. And therefore, the state does believe that detention is still necessary despite the treatment program, as we have concerns about the victim and the victim's safety. And previously stated in the complaint, defendant's characteristics include that the defendant has a history of stalking, harassment, or terroristic threats towards any victim. And accordingly, Your Honor, for all the above stated reasons, the state requests that this court keep the defendant detained. Thank you.
Very well, thank you. This matter has come before the court on a motion to reopen detention. The defense is now submitting that the defendant has been accepted into a bed at Cura, a long-term residential drug treatment program. The court does find that the availability of that bed at a long-term treatment program is a material change in circumstance that warrants the reopening of detention. Further, the court finds that the state is no longer able to prove by clear and convincing evidence that there are no conditions or combinations of conditions that can be imposed to reasonably assure the defendant's appearance in court, the safety of the victim or the community, or that the defendant will not obstruct or attempt to obstruct the criminal justice process. And therefore, I will allow the defendant to be released on level 3+ home detention into the custody of Cura.
Okay, so in case you don't remember, I'm going to say it again because there are some new people here. This is New Jersey. So in New Jersey, there's no bond or bail. Unless you're already like grandfathered in with a case that you have bond or bail on. But they changed the laws. So in New Jersey, when you get charged, the prosecutor can either tell the judge, we want him detained, period. There's no one can get over that. Once the prosecutor says we want him detained or her detained, there's no bail. You just stay in jail. You stay in jail until you can get in front of a superior court judge. And the superior court judge decides whether you stay detained or you can get out. Now, if you get out, again, you don't have to pay a bail to get out. When you get out under certain conditions. Everybody gets out under certain conditions. It's level 1, level 2, level 3. So, like, if you're just in there for, something minor, you might get a level 3 or whatever. You just have to call your probation officer once a month. Level 1 is, or whatever. I don't know if I have it backwards. I don't know if level 1 is higher than level 3 but you get the picture. Level 1 is calling every day or calling once a week and stopping in once a week. And then they have other conditions. Your address, like you have to stay at a certain address. You can't go anywhere else. You can't drink. There's no contact orders. They can put all these provisions on you just like they do when you have a bond. But that's how they do it in Jersey. There's no, one is higher. Okay. So there's no money. You don't have to pay money to get out of jail. It just depends on what you did.
And order that he have no contact with the victim. And that
Thank you, another Smith. I almost missed it. Thank you.
at the conclusion of his residential program at Cura, that he will need to make a new motion before the court to modify the conditions of his release to allow him to live elsewhere. And with those conditions in place, the state cannot establish its burden. Mr. Soto Taja, I am going to allow you to be released today. I need to therefore advise you of the terms and conditions of your release. So I need to swear you in. Please raise your right hand. Do you swear or affirm the testimony you're going to give the court today will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
All right, you can put your hand down. You must appear for all scheduled court appearances. Your next court appearance on this matter.
Merry Christmas, Elite.
January 6th.
Post indictment. You have a post indictment arraignment on January 6th, 2025. You must notify pretrial services immediately of any change of address, telephone number, or other contact information. In this instance, I'm allowing you to be released into the custody of Cura, the Community United for Rehabilitation. And you're going to be required to remain at their address. Do you understand that?
Yes, Your Honor.
Okay. At some point, I presume that you're going to do well in the program, and at some point, they're going to recommend that you can be stepped down into some kind of an outpatient program. Before you leave that facility, you need to contact your attorney, come back to court, and make a motion to modify the conditions of your release to allow you to live somewhere not in their custody. You understand that?
Yes, Your Honor.
Okay. Do you have a cell phone number?
For me?
Yes.
Yeah, I got a cell phone number.
Can you put the cell phone number on the record, please?
It's 908 937.
Okay. Very well. Very good. Okay. You shall not commit any new offenses while you're out on release. You shall avoid all contact with the alleged victim. Now, that's really important, given the nature and the seriousness of these charges, and that you understand it. You're not allowed to contact this victim. That means you can't call her, you can't text her, you can't try to contact her through social media. It means that you're not allowed to go to her house or where she works. You're not allowed to contact her in any way at all whatsoever. You understand that?
Yes, Your Honor.
Further, if she tries to contact you,
What was that, Fuzzy? What were you saying?
she's not under any court order, but you are. So if she contacts you and later it becomes learned that you were having communications with her, you're in violation of my order. You can be charged with a new crime of contempt of court for violating my order. You could be detained for the new crime. Or the state could file a motion to revoke your release on these charges. You understand that?
Yes, Your Honor.
Okay. Make sure you don't have any contact with the alleged victim whatsoever. You are you're going to need to report telephonically once every other week and by video once every other week with pretrial services. So you're going to be released on the 19th. I'm going to issue a transport order allowing you to be transported from the county jail to Cura. All right?
I'm sorry, Your Honor. My things are in Union County still.
Yes. So
Internet's fine here. There's nothing wrong. And I can't dox Fozzie because he'll dox me right back. Is it breaking up for you guys? Is it lagging?
when you have court appearances, Cura is going to need to make arrangements to help get you transported to Union for your court appearances.
All right, Your Honor.
Stay in touch with your attorney. Your attorney may ask to have some of those court appearances adjourned or carried to allow you to get through the initial 30 days of treatment. Oftentimes that involves a blackout period, but your attorney's going to need to make requests to the court to get that done. Don't just assume that it's been done, all right?
It's you, Linus, not me.
Yes, Your Honor.
You shall refrain from possessing a firearm, destructive device, or any other dangerous weapon. You shall refrain from the use of alcohol or any use of narcotic drugs or controlled substances unless they are prescribed to you.
That's a
You're being
pineapple.
placed into pretrial home detention at Cura in the custody of Cura. You're only allowed to leave to attend court appearances, to meet with pretrial services if necessary, for attorney consultations, and in the event of a medical emergency, you can leave to attend that medical emergency, but you're going to need to provide proof that that emergency existed and where it is that you went for treatment. As I said, you'd have no contact with the victim. You must notify the court immediately in writing if you're detained in jail, in prison, or otherwise cannot appear to court proceeding. If you fail to appear to court proceeding and then you're arrested in another state or in another jurisdiction, then you agree to waive all rights to extradition proceedings under the New Jersey statutes and the demanding states or jurisdiction statutes in regards to extradition law. Your failure to appear, a violation of any of the conditions of your release, or the commission of any new offenses could result in the issuance of a warrant for your arrest, increasingly restrictive conditions, revocation of your release, forfeiture of any monetary bail, and your possible detention. You understand all of the terms and conditions of your release, sir?
Yes, Your Honor.
Okay. This is an opportunity for you to try to get clean so you can get a handle on what's going on in your life and hopefully go on to live a happy and productive life. If you decide this program isn't really working for you and you walk out, the state's going to file a motion to revoke your release and a bench warrant is going to issue for your arrest. You understand that?
Yes, Your Honor.
At that time, I'm unlikely to say, well, this guy just needs another shot at rehab. What's more likely going to happen is I'm going to detain you and then perhaps allow you to get rehabilitation through the Hudson County treatment program at the Hudson County Jail while these charges are all pending. You understand that?
Yes, Your Honor.
Okay. Then I hope this program is really beneficial to you and that you do well. I genuinely do. And this is your shot to go do it. So you'll be released on the 19th to Cura. Make sure you stay in touch with your attorney. Make sure you stay in touch with pretrial services. All right?
Yes, Your Honor.
All right. Your matter is concluded. You can let the jail know that you're done. And I believe now we're going to break for lunch. We'll be back at 1:30.
Well, guys, thank you so much for coming out today. Merry, Merry, Merry Christmas. I hope you guys have a great day. Hop in Discord. The link is in my channel description. If you're alone, if you're not alone, hop in Discord and bring your family. Just kidding. Don't do that. We don't want to talk to them if you don't want to talk to them. So here's what I'm going to do. I have a couple trials. So I have a couple trials where, you know, they were a couple days long and I got what I got. I think I have some verdicts on them, but I can't do a trial unless I have a verdict because you guys go crazy if I do that. And rightly so. It's right. So I'm going to go now and I'm going to sort through these trials. And if I can find one where I have a verdict, even if I don't have the whole trial, if I have a nice verdict and some good body cam footage, which I do have that, then I'm going to do a nice long stream. I'm just going to play the trial. And if anybody is, you know, wants to hang out for Christmas, they can hang out. Please don't feel like you have to go do Christmas with your family. You don't have to be on YouTube. Go do Christmas with your family. If you can't do Christmas with your family or you want to just watch videos instead, I'll put one up. But don't feel you have to attend or anything. Go do what you want to do. Love you so much. I love you all 3,000. 3,000. Thank you so much for coming out. And I will see you again really, really soon. Merry Christmas, guys.
Got these life echoes, digital dreams. Through the screen, her blue eyes gleam. Wicked humor, sharp as a knife. Her stream sparks electric light. Late night when the world sleeps, she's the friend that always keeps. Giggles roll like thunder loud. She stands out in any crowd. feels just right. Even when my world turns gray, with a giggle, she lights the way. Kathy's love.